Today we have chosen to speak on interlocutory orders under the Code of Civil Procedure. You will appreciate that under the Code of Civil Procedure, there is no definition of interlocutory orders. It is actually, it is mentioned in Order 39, what are the interlocutory orders under Order 39, Rule 6, but without giving definition. The definition clause of the orders, judgment and decree is necessary to appreciate what are the interlocutory orders or intermediary orders. Normally, the interlocutory orders are passed during the pendency of a civil suit. No sooner the suit is decreed, either resulting in dismissal or allowing, the interlocutory orders stand vacated. Now let us see. So I will give the illustrations in various suits how the interlocutory orders are passed. Now first remember the definition of the expression order, section 2 subclause 14 in the CPC, that deals with the definition of a order. Order means a formal expression of any decision of a civil court which is not a decree. So decree is defined under section 2.2, which is a final adjudication. When you see the, I will not be reading the entire definition, just will give you the gist of the meaning of it. Decree means it's a final adjudication. Mean an order which conclusively determines the right title interest of the parties. Please note that. Then the learned judges who write the orders and also passing a decree, they will have to necessarily give judgments. Now that judgment is defined under the provisions of CPC section 2 subclause 9. Now let us see what does it say. Judgment means statement given by the judge on the grounds of a decree or order. So judgment is given, the grounds are given both in an order which can be interlocutory order, which can be intermediary order, or which can be a final order, a decree. So judgment is a combination of which combines interlocutory orders as well as a decree. Now once again I will tell you, under the Code of Civil Procedure, before I give examples to you, there are, almost every order either appealable or revisable. Either you can file an appeal against the certain orders, certain orders are not appealable. Almost every judgment and decree is appealable under section 96 of the Code of Civil Procedure. Then certain orders, certain interlocutory orders are appealable under section 104 and order 43 rule 1 CPC. Certain orders, I am making a quote you, certain orders which have the effect of determining or conclusively affecting your right title interest. Some of the orders, like an order of injunction is granted against the defendant, it is made appealable under order 43. An order allowing amendment of the pleading, either plain or written statement under order 6 rule 17 CPC, they are not appealable. And by virtue of the definition inserted in section 115 CPC, which speaks of revision, a revision will not lie against an order which does not finally decide the suit. Please note that here. Again, you cannot file a revision in the present matter under the Code of Civil Procedure. There are under certain special statutes which says that if your right title interest is affected, the amendment application which is refused by the trial court, an appeal would lie to the special court. but not under the Code of Civil Procedure Code. So in the Code of Civil Procedure Code, the amendment application under Order 6, Rule 17 is an interlocutory order which does not have the effect of deciding the suit. In such a scenario, when there is no appeal under Order 43 or Section 104, or there is appeal under Section 96, nor a revision would lie under 115, in some of the cases, you can file a writ petition under Article 227 of the Constitution of India on the ground that the learned judge has not exercised jurisdiction which is vested in him, or there is a material irregularity in the finding given by the judge. Okay. Now, coming to what exactly are the interlocutory orders. So, number one, you have I will give you illustration of a suit. Then I will also discuss the interlocutory. Some noise is coming here.
Hi, can you mute your audio?
One of you, please mute the audio.
अच्छा रूपरेखा मैम रूपरेखा चाबरिया मैम
कौन है डिगामा रूपरेखा yes now I will give you the illustrations of the interlocutory order which is not defined in the Code of Civil Procedure Code. So essentially you have to bear in mind the definition section 214, section 29 and section 22. Section 214 deals with an order which can also be an interlocutory order. An order which is affecting the rights of the parties, an order which may not be affecting the rights of the parties. The illustration is that here the interlocutory order affecting the right of the ground that it is causing waste and damage, it is substantially affecting your rights. Appeal would lie under Order 43. So that is an order. An order I gave it to you, for example, the court has not issued summons upon a particular witness under Order 16. It is not appealable. It does not affect your rights. And the court has refused to pass an order regarding admissibility of document under the Evidence Act. Now, when pleadings are completed, plain written statement issues are framed by the court will pass a direction. The parties are hereby called upon to take inspection of their respective original documents and file their affidavit of documents. Filing of the order passed under Order 13 with regard to documents to be filed is again in an interlocutory order which may not be affecting your rights. Then when the parties have tendered their evidence along with the list of documents under the provisions of Order 18 Rule 4 CPC, then the trial court judge is called upon. So you are a plaintiff. The plaintiff's documents will not be automatically admitted. So you have filed the evidence and the list of documents. The Evidence Act mandates that here the best evidence which the court will accept is the primary evidence which is defined under section 60 and 62 of the Evidence Act. Isn't it? The original documents. In the absence of original document, you have to lay a foundation for tendering secondary evidence. Secondary evidence means it can be Xerox copies, it can be typed copies, it can be certified copies. Those are examples are given under section 63, 65, 66 of the Evidence Act. Now, when you seek to when you tender this document before the trial court, your documents are not automatically admitted. The trial court will pass an order, keep it for admissibility and non-admissibility of the document. The defendant is required to give his say in the matter, whether he is admitting a particular document, whether he is not admitting. Because plaintiff is required to confine his pleadings or evidence to the issues before the court of law. You cannot travel beyond the issues, and the documents which are sought to be tendered beyond the issues may not be admissible. The order which the trial court passes with regard to admissibility is under section 136 of the Evidence Act. Yes, the document which is produced is certified copy coming from the government document. It has been issued in the due course of business, and it is a public document within the meaning of section 74 of the Evidence Act, admit. Election record, it's a public document, admit. If it's a Xerox copy of the letter which you wrote to the defendant, the court will not accept it. Or an email message which you produce without certificate under section 65B of the Evidence Act is not admissible. A document of a third party who is not a party to the proceeding, if you produce it, may not be admissible. Court will mark the document as, even assuming for the sake of you are producing a will of your grandfather without the attesting witnesses affidavit, it may not be admissible. Section 68 mandate that it must be attested by one of the witnesses. So court will pass this order with regard to admissibility under section in the Evidence Act 136. Now, this order, suppose the court has rejected your application. Say, I am not admitting. This again, it is called interlocutory order. Why? Because it may be causing you some hardship. This order is neither appealable nor a revision would like. You have the scope to argue before the court at the time of the final hearing, or you may choose to examine the witness during the trial, or at the appellate stage, you may tell the court that the learned trial judge has committed an error which is apparent on the face of the record. The finding is arbitrary. The finding is capricious. It requires interference. But before the trial court, you cannot waste your time. So it is an interlocutory order which may not be affecting much of your right. It may cause inconvenience to you. Now in Shah Babulal Khimji's case, AIR 1981 Supreme Court, the Bombay High Court rejected the application for appointment of a court receiver and injunction. Now all of you know that the Bombay High Court, when a single judge is passing an order, rejecting or granting an order of injunction, there is an appealable order under clause 15 of the latest patent. Now, what is admissible in clause patent is the expression used is judgment. Now, again, judgment is not defined in latest patent, but it is defined in the Code of Civil Procedure Code. Now, they say that here, the Shah Khimji's case, Supreme Court took the view that here, the order which was passed by the division bench of the Bombay High Court, that appeal would not lie, refusing to pass an order of injunction, refusing to grant an injunction is erroneous. Why? Because the Supreme Court gave an analogy that almost all orders falling within the ambit of under order 43 of the Code of Civil Procedure from A to W, they are all appealable orders. So injunction and receiver are falling within the ambit of Order 43 and Section 104 CPC. So though they are interlocutory orders, but they have the effect of affecting your substantive rights. So this is a category, first category of the interlocutory order. When you have sought an order of injunction against the defendant from creating third party interests. Suppose you may have been dispossessed by your owner, the landlord, from the premises without following the due procedure established by law. You have two remedies in the court. Either you can go under Section 6 of the Specific Relief Act without title to the civil court to put me into possession. Or you may go to the special court under Section 33 of the Maharashtra Rent Control Act, that a decree of eviction, that declaratory suit may be filed for a declaration that you are a tenant of the premises and the order has been, you have been evicted erroneously and you should be reinstated in the premises. So in that suit, you may take out an interim application. It is called, now we call INT application or interlocutory INT application in Bombay city. Nowadays, earlier notice of motion, now we take out IA. Like Supreme Court, we take out IA interim application. In the interim application, you seek an order that this Honorable Court be pleased to appoint a court receiver, High Court Bombay, or a court receiver of this court with a direction to take possession of the property as I have been dispossessed without the due procedure of law by the defendant. The court may refuse your injunction. Like in Shah Babulal judgment, the Bombay High Court appellate bench held that the order passed by the single judge is not a judgment and we are not going to entertain the appeal. The Supreme Court said nothing doing. Supreme Court says that it is an order, refusing an order of injunction, passing an order of injunction is falling within the ambit of Order 43 Rule R of the CPC, and it is, though it is an interlocutory order, it is affecting the right, title, interest and appealable order. Now, coming back to Order 6, Rule 17 CPC. So you filed a suit in the City Civil Court or Bombay High Court or Small Causes Court. Whatever may be the nature of the suit, there are several nature of the suits we discuss, isn't it? So, in a suit for specific performance of a contract, you entered into with the builder to put you into possession. You have been paying money in installment. The building is yet to come within 3 years' time. There's the agreement of sale registered with the builder, isn't it? You have substantially made payment and full payment. The builder was to put you into possession. Now the rates of the property in the city of Mumbai are gone up. Mumbai, Calcutta, Madras, wherever it is. The builder's intentions are not honorable. He doesn't want to give you the property. So you file a suit under Section 10 of the Specific Relief Act and apply for an order of injunction under Order 39, Rule 2, 1, 2 and 1, 2 of the Code of Civil Procedure. Rule 1 and 2 speaks of where your property is in danger. You are sought to be eliminated. Your property is being sold in auction. Then there's the Order 39, Rule 2, there's a breach of contract. So under the Specific Relief Act, under the breach of contract, you have a right to file a suit. Now you apply for an order of injunction that the builder has, without your consent and permission, has entered into agreement with third parties who are sought to be brought on record. Isn't it? The court may grant you injunction under Order 39, Rule 2. After the grant of injunction, your suit is in progress. Then you want to make an application to the court that this Honorable Court be pleased to grant me permission to amend my pleadings. application for amendment is filed under Order 6, Rule 17, the order that may be passed by the trial court is called an interlocutory order, because it is not a final order. It is not deciding the suit. If it decides the suit, it become a decree, isn't it? And it is not deciding the suit. It is only passing interlocutory order of injunction or appointment of a court commissioner under the provisions of Order 26, Rule 1 CPC, or under Section 75 of the Code of Civil Procedure. So these are all interlocutory orders which are passed during the pendency of a suit. So some of the orders are affecting the rights of the parties. If it is rejected, the plaintiff rights are affected. If it is granted, the defendant rights are affected. So the order granting an amendment, refusal of order is not brought within the scope of either under Section 104 CPC, which speaks of appeal from orders, or under 43. It doesn't mean that you are remediless. You have a remedy to go in a writ court under Article 227, which is a very narrow remedy. A writ court will exercise writ petition under Article 227 with great circumspection and caution, normally not like to interfere, because the court will say interlocutory order, final suit mein dekha jayega. If your suit is dismissed or decreed, we are there. It is open for you to urge all those points under Section 96 of the Code of Civil Procedure Code, isn't it? So they will settle. Suppose you are a defendant, you did not appear before the court of law. An ex parte decree has been passed against you. You have been ordered to be evicted from the premises. Now you make an application under Order 9, Rule 13 CPC, though it is in the nature of an interlocutory order. Application for setting aside the decree is an interlocutory order, but affecting your substantive right, it's made appealable. Please note that. An appeal would lie both under the provisions of Order 43 and under Section 96. You have a right to choose whether you want to go under 96, which is the final decree. It's a decree, final order. And again, your application under Order 9, Rule 13 is dismissed by the court. It's an interlocutory order. Order affecting your right. Now, for example, during the pendency of a suit, you may take up the plea that here your neighbor has encroached upon your land. You are in possession, occupation, enjoyment of 5 acres of land. Your neighbor has 2 acres. There is encroachment take place. You file a suit, title suit you may file under the Specific Relief Act for a declaration that you are the owner and he has no right to encroach upon, and seek a perpetual order of injunction, restraining him not to enter into. At the same time, you take out notice of motion or interim application for an order of injunction under Order 39, Rule 1 CPC, read with Section 37 of the Specific Relief Act. It's an interlocutory application. Restraining him not to enter. Court may grant the injunction, may not grant it. Now, there are well settled principles of law for granting an injunction. Plaintiff must prove his case. There must be a prima facie case. I mean, it must appear to the court that you have a substantially good case. You are likely to succeed in future in the trial. Number 2, to whom irreparable loss will be caused, whether by granting to the plaintiff or by refusing to the plaintiff or granting. So these are the paramount factor for consideration in a prayer for injunction, which are granted temporary injunction under Order 39 of the Code of Civil Procedure, and also in the supplemental powers of the CPC under Section 94. 94 A, B, C, D, E, F, checkering up, these are all supplemental proceeding. Now, in the said proceeding, which I gave you example, where you sought an order of injunction, you may tell the court, please appoint a court commissioner to find out the position of the land, my land and the defendant land. They are adjacent land. And I am producing before the court my title deeds from the revenue authorities. And you may not be having the map from the government. You have produced your map. As an interim measure, you may make an application to the court under Order 26, Rule 9 CPC, read with Section 74, and Order 39, Rule 7, for appointment of a court commissioner to take inspection. This order is also interlocutory order. Please note that an application under Order 26, Rule 9 for appointment of a commissioner for the purpose of visiting the property and submitting a report, taking photograph for elucidation, measurement, is an interlocutory order. Though if the order is allowed, there is no chances of appeal. It's not an appealable order. And revision also will not lie under 150. Your only luck is to go to the High Court under Article 227 of the Constitution, which jurisdiction the High Court does not like to exercise as a matter of course, but with great circumspection and caution. So it's an interlocutory order. Again, the examples of interlocutory orders, when you open Section 94 of the Code of Civil Procedure Code, you will find it here. Just open Section 94, Sally. They are called supplemental proceeding. Yes. Supplemental proceeding के अंदर देखिए, in order to prevent the ends of justice being defeated, the court may, if it so prescribe, issue a warrant of arrest. A warrant of arrest is issued both under Order 39, Rule 2A. Rule 32A, disobedience of the order of injunction. Order 39, Rule 2A is a disobedience of the order of injunction, under which the court has power to convict a person, whoever is committed the breaches, to imprison him in civil prison for a period of not more than 3 months, and attach his properties, movable and immovable, under Order 39, Rule 2A, and the attachment cannot last for more than 1 year. And the court has power to sell the properties. These are interlocutory orders. And out of the sale proceeds, the court can pay to the agreed party compensation, and the remaining amount is disbursed to whoever is entitled to it. It's an interlocutory order. Of course, under Order 39, Rule 2A, it is appealable order. But an order passed here, issue a warrant of arrest. Now, why warrant of arrest is issued here? Now, when a suit is filed by the plaintiff for recovery of, say, 1 crore from the defendant, plaintiff will take up the plea. The defendant is leaving the jurisdiction of the court. He is migrating to foreign countries. He is selling his factory. He is settling down in UK, USA, somebody, whichever country. So as an alert plaintiff, what will you do? You will take out an application under Order 38, Rule 5, CP 125, attachment before judgment. Please note that these are interlocutory orders again. An attachment before judgment is passed during the pendency of the suit. Now, the defendant doesn't obey the order, the court has a power to issue warrant here. It is not only the criminal magistrate exercising power under the CRPC issues warrants. Also, the civil court under section 94A has power to arrest the defendant and ask him to give security. So when you read Order 38 of the Code of Civil Procedure, that will give you the examples in what cases the court can arrest the past orders of injunction, attaching the properties, judgment before, judgment before decree, the court can attach the ABJ, bolte na, attachment before judgment. So before final judgment also you can come. So a drastic order which is passed under Order 38, which can be implemented under Section 94A, it is a warrant, is again an interlocutory order. Then 94B ke andar, directing defendant to furnish security. If he is running away, the court will say that here, before we put you in the jail or give you hereby called upon to give security for the amount of the suit, 1 crore amount, you give the security. We'll get it deposited in the nationalized bank and it will earn fetch interest. Whoever win the case, he will get it. So if he declines to give it, warrant will be issued. And again, 94C speaks of granting temporary injunction in case of disobedience and commit the person to civil provision attaching the property. So this provision 94C is also equivalent to Order 39, Rule 2A CPC. This is nothing to do with the Contempt of Court Act proceeding section 2A and 2B, 2C. They are different contempt of court proceeding. Only the High Court can take action. Here when the CPC, every civil court has power to take action. So these are interlocutory orders which are passed. The 94D ke andar, the court can also appoint a court receiver of the property and enforce performance of the duties attaching the properties. There is another provision, Order 40, Rule 1 CPC, which empowers the court to appoint a court receiver before or after the decree. I mean, it's an interlocutory order. See, before mean during the pendency of a suit. After the decree mean when a final judgment is passed, both under Order 40, Rule 1, as well as under Section 51D, which relating to execution, the court passes an order of appointing a receiver. Normally an order, though the order appointing a receiver is called interlocutory order, but it is seriously affecting the rights of the parties. This is made appealable under the provisions of Order 43, Rule R, and also in case it is a judgment passed by it is an order passed by the High Court under the over CJ by the single judge, it is appealable before the division bench in letters patent appeal. Under clause 15, it is a judgment. Though it's an interlocutory order for which you have to go through Shah Babulal Shah Khimji's judgment of the Supreme Court. So 94 speaks of all these interlocutory orders. Some of them are appealable, some of them are non-appealable. These orders will remain in force till during the pendency of a suit. Once the court passes a decree can be dismissal of the suit, decree can be suit being allowed. By the judgment and decree, it is known as. Then the temporary orders will be normally vacated, such as injunction, court commissioner, they will be vacated. But for order with regard to court receiver appointed under Order 40, Rule 1 CPC or under 94, the plaintiff, the person who appointed the receiver, must obtain a specific order from the court for discharge of the court receiver. Because there are judgments of the Bombay High Court and Supreme Court, merely dismissal of the proceeding will not ipso facto discharge the court receiver. There must be a specific order from the court. There is a judgment of Justice Deshpande of the Bombay High Court and of the Supreme Court he has referred to. Please note that here, you must obtain a specific order for discharge of the court receiver. Unless and until the court passes an order of discharge, though the court receiver is an interlocutory order, will not be automatically discharged. Okay, remember this. Section 94 deals with all these orders. Then I will take you to Section 75, incidental orders, which are also interlocutory orders. Up खोल Section 75. If you are having a CPC book, you may open it. I will refer and give you illustration. Section 75. These are all orders are again here interlocutory orders. Section 75, incidental proceedings in Part 2. Number 1, power of the court to issue commissions. Subject to such conditions and invitation, the court may issue commission. Number 1, to examine any person. Now, this power is also there with the court under Order 26, Rule 1 CPC. See, many judges don't have time to record evidence. And many litigants, by virtue, on account of their age, disease, whatever may reason, unable to come to the court. In the olden days, of course, we have now video facilities. So they may make an application to the court, appoint a court commissioner to record. You make an application to the court that my client is suffering from A, B, C disease. He is unable to come to the court. This honorable court may currently appoint a commissioner, a junior advocate, to record the evidence. Your application is not supported by medical certificate. The court may reject the application. It's an interlocutory order. But if you are produced with a medical certificate, with the true facts, the medical certificate is accepted as a conclusive evidence under Order 26, Rule 1 CPC. So it's an interlocutory order. Now, number 2, 75B speaks of to make local investigation. So I gave you illustration. When a suit is filed, somebody has encroached upon your property, or if it's a landlord and tenant suit, tenant has carrying out structural repairs without your consent and permission of the municipal corporation, or a trespass suit, a trespasser is encroaching upon your further land, in a partition suit that your siblings are misappropriating the funds and property, court will, upon your application, will make local investigation. Even for the purpose of determining the mean profits, the valuation. For giving comparative rents. What is the annual letting? The architects are the best person who act as the court commissioner in this matter. Court commissioners are appointed both under Section 75, Order 20, Order 26 and Order 39 Rule 7 CPC. So these are all interlocutory orders. Rejection or allowing the application are not necessarily appealable orders. They are not appealable orders. Please note that. What are the appealable orders? You will find under Order 43 and Section 104. जहां जहां पे उतने मेंशन किया है उतने अपील होते हैं. And by no stretch of imagination you can file a revision under 115, because now with the amendment of the CPC, interlocutory orders, only final orders can be challenged in a revision. Mean an order which had the effect of disposing of your suit. Appointing a court commissioner, it doesn't dispose of your suit. It's an interlocutory order. Okay, interlocutory order means an order passed during the pendency. Yes. Number 3, to examine or adjust accounts in a partition suit. In a suit for rendition of account. In a suit for dissolution of the partnership firm. In a suit for administration. The court passes these orders appointing commissioners to take. Court itself doesn't have time. Court commissioners can be advocates. Court commissioners can be architects. Depending upon the nature of the relief sought, the court appoint. Then the 4th is to make partition. Now, under the provisions of the Partition Act and Transfer of Property Act, you learned it here. What is partition? Partition by metes and bounds. In a suit for partition, ultimate decree is decree for partitioning the property and giving the shares to the parties. But in between what? Your property may be in the hands of your uncle, your grandfather's property. He is misappropriating it. He is not giving you a share. You make an application to the court to appoint a commissioner to take accounts. Direction will be given to the defendant to give full particulars. Then E speaks of holding scientific, technical, expert investigation. Where there is a forgery taken place, the will of your grandfather, father has been fabricated by your brother. Signature is not yours. So you make an application to the court that handwriting expert be appointed. Or the court may compare the signatures. Scientific persons are appointed to give their valuation. So such orders which are passed are again interlocutory order. These orders are passed under the provisions of the Indian Evidence Act, section 47, 48, 49, and also under the Code of Civil Procedure. Then F speaks of conducting sale of the property which is subject to speedy natural decay and which is in the custody of the court pending the determination of a suit. When some property is brought before the court of law, subject matter of the suit is a perishable condition that cannot be kept. The court will appoint a commissioner and dispose of the property. The sale proceeds will be distributed to person who is entitled to it. So these are the interlocutory orders under section 75. And orders 76, 7, letter of request, commissioner of appoint, these are all again interlocutory orders. Isn't it? 79. Order issuing witness summons under order 5. Again, interlocutory order. Isn't it?
Sir,
Then, yes.
so could you repeat? If the will has been fabricated by brother-in-law, then again there is the relief to be sorted. Is the interlocutory is an application for appointment of court commissioner to check if the signatures have been.
Yes. Handwriting expert will come, compare these signatures, whether genuine or not. In the meanwhile, the court will take into custody the document itself. The document may be impounded. See, under the provisions of the Code of Civil Procedure, Order 13, it contains a provision for impounding documents. Please note that these are all interlocutory orders which may be affecting a party, which may be causing inconvenience. But the court has to decide the what is the truth of the matter, what is not the truth of the matter. Okay.
Yes, yes.
पूछते जाओ. I'll be happy to answer your queries, all of you, because the topic is very vast, and there are so the interesting judgments which you can go through to decide some of the interlocutory orders which have been mentioned. And Shah Babulal Khimji versus Jayaben Kania's case, 1981, 4 SCC, page number 8.
Yes.
This is one of the landmark judgment which went from the Bombay High Court to Supreme Court as regards the powers of the appellate bench of the High Court Bombay to entertain appeals against the refusal of order of injunction and receiver, whether they are falling within the ambit of expression called judgment within the meaning of clause 15 of the latest patent. Now, Justice Gawai's judgment is of the Supreme Court following upon here. Now, some of the illustrations I'll give you from the judgment of the there's one more judgment of the Supreme Court in Shamel Cell versus Sham Steel, 2023, 1 SCC, page number 634. Yeah.
Sir, a few more questions. Sorry to interrupt.
Yeah, please do that.
Sir, you said that letters sent to an original are also subject to admissibility. So if I have a Xerox of the letter, then also the court may not find it admissible. So then, what is the best practice to retain letters that we are sent, original letters?
Your original letter, you send it, and your evidence should be there. This letter is written by me. It is signed by me. The contents are correct.
So affidavit or subject.
It is in the examination chief, may you file affidavit under Order 18, Rule 4 CPC.
Okay.
So in the CRPC, you don't file affidavit. You have to go in the witness box. You as a lawyer have to ask him, please tell the honorable court, what are the documents? This particular letter, did you write any letter to the accused or to the complainant? Yes. Do you have it? Produce it. Then, is it the same letter? Who has signed it? You cannot tell him you have signed it. You question the interrogative form. Who has signed it? In what connection you wrote it? Then if he says it is written by me, it is my signature, the contents are correct, then you can request the court that this honorable court be pleased to take on record, exhibit this document. Okay?
Exhibit this document.
Exhibit this, the document be exhibited. Mean prima facie the evidentiary value is accepted, but mere exhibition of a document is not evidence. But if the witness has said that it is my document, my signature, contents are correct, then it is evidence. Then it is evidence. Under the Evidence Act, a document which is 30-year-old, you produce it of your grandfather's under Section 90. That the court may take into record, yes, it is admissible. But mere exhibition of the document is not evidence unless you prove that it is the handwriting of your grandfather. Unless the other side refutes it. This is in connection with the transaction of the business of the suit. Under Section 32 of the Evidence Act, there are 8 illustrations. 32.1 relating to death of the person. 32.3, 32.2 relating to family transaction. 3, the business, customs, usages. So there are 8 illustrations. So your document must fall in within this document.
Okay.
Then you can say that the document can be admitted. If the court rejects the application, it is an interlocutory order. Because
Yes.
ultimately, you have a chance to get it admitted during the appeal. Under
Later
section
stage.
96, the appellate court, because appeal is the continuation of the suit.
Right.
Because the reason why you are being stopped from appealing at this stage of the suit is that the floodgates of the courts are not open for of the high court or appellate court. Every order is made appealable, then the courts will be flooded. Already our Indian courts are over flooded, isn't it? So our suits are taking 10, 20, 30 years. So
Right.
that is why there's a discouragement by the parliament, legislature, that each and every order cannot be challenged. You wait, have patience.
Justice will.
Yes, that is how it is. Of course, if it is a serious injury is being caused to you, if the order is not appealable, if the order is not revisable, you can go and writ under Article 227. Or at the time of the final hearing, you may convince the same judge, my lord, is the material and record to show that this document is admissible. So at the final hearing of the judgment and decree, final argument when you take place under Order 20 CPC, when judgment and decrees are passed, you can urge it. Please note that a finding recorded by the trial court at the time of the passing, refusal, rejection, or allowing the interlocutory application, that finding is not binding upon the court at the time of the final judgment and decree. Remember this. Suppose the court has come to the conclusion at the time you filed a suit against the defendant for a declaration that is a trespasser. You sought an order of injunction. The court is writing a prima facie finding. In my opinion, the plaintiff has not been able to prove it. He is not able to prove the document. So injunction is refused.
But at the final time, they can.
Yes, subsequently you gather a document, produce witnesses, दिखाएंगे आप. Then the defendant cannot say, my lord, injunction was refused and the court has passed a finding that there is no prima facie case and his suit should be dismissed. No, that finding is not binding. It's called interlocutory finding, which does not affect the final outcome of the suit. Parties you have a right to adduce the evidence, because at the time of the injunction, parties are not leading evidence. They are not going in the trial box, isn't it? Evidence Act doesn't come to play at this stage, at the interlocutory stage. So, summary manner, the court is deciding. It is only when a final decree suit is decided after examination of the plaintiff, defendant, various witnesses. So, the finding recorded by the court at the interlocutory stage is not binding. That is why many of the High Court, Supreme Court judges say that dispose it of, appeal, dispose of, dismiss, and the finding recorded by us should not be influenced by the final judgment. The trial court should not be influenced. See, always it is their finding. Now, some of the illustrations which are given, I'll give it to you in the judgment of the Supreme Court. Read it here.
So this order is a finding recorded by the trial court is not binding on the final judgment. A finding recorded during the pendency of the trial is not binding. This statement is a order. This is which order?
If in the interlocutory application, suppose you move the court after filing of a suit, injunction under Order 37, Rule 1, Order 39, Rule 1 to me injunction liya aapne. The court will say that at this stage, prima facie, you have not proved your case. There is no apprehension to grant injunction.
Got it.
Okay. Then ultimately you prove your case in trial.
Got it.
Ultimately, you prove your ownership rights. Ultimately, you prove that the defendant has no right title interest. Defendant may set up the plea that he is in possession as an adverse possession. He has not been able to prove adverse possession. So you have been able to prove the 712 extract of your grandfather, will of your grandfather, how you are entitled to possession. You have been able to prove the property card, which documents which are come in the trial court. So at the time when you filed a suit, the documents were not available. The defendant may have taken the plea at the injunction stage. Your father had sold it to me. He will produce a bogus sale deed, isn't it? So on the basis of the bogus sale deed, your injunction will be rejected. Then thereafter, what you do cleverly, you appoint a handwriting expert. He will give a finding that this is a forged signature. Then you come to know from the bank record, no consideration is paid to your father. If there is no consideration,
There's no sale.
no sale. So this you are proving at the final stage. So whatever finding the learned judge recorded at the time of the injunction is not binding. So you have been able to prove your case that the document is fabricated. There is no consideration. Expert has given you finding, handwriting expert. You examine you as a witness. So you proved your case. So court will say that plaintiff has proved his case. Issue number A is proved non-conformity. Suit is decreed. Defendant is hereby called upon to quit, vacate, hand over possession within a period of 1 month, 2 months, 6 months. So that is a final judgment. So final judgment or interlocutory order, there is a lot of difference. So what is a decree which is defined? We just read the definition in the CPC. Decrees are given in order 20. CPC खोलेंगे यहाँ पे various decrees. A decree passed in movable property, the decree passed in immovable cases, a decree passed on mean profit, decree for specific performance, a decree in a partition suit, a decree in a insolvency suit. There are various decrees. Order 20 खोलेंगे आप, you will get plenty of them in administration suit. So they are all final. They are finally decided orders. Of course, they are appealable. Every decree is appealable under section 96 of the Code of Civil Procedure. Please note that here. Final decree. Either it goes to the, if it's a lower court, you go to district court. If the district court decree, it goes to high court. Okay. Then some of the orders which I would like to cover to you, what are the, for example, order refusing adjournment is an interlocutory order. You cannot go in appeal. You may make an application to the court. My senior advocate is not well. He is bedridden. Honor may kindly give me time. The court reject your application. You cannot say I'll go and appeal. It's an interlocutory order. Rejecting an adjournment is interlocutory. Then order refusing summons or additional witnesses. Under the provisions of Order 16, you may take up the plea that I want to examine a particular witness. The court will ask you on what issue. If you are unable to explain what are the issues in the matter, why you want to examine this particular witness, already you are overburdening. The court will go by the quantity, not the quantity, quality of a witness. If you have been able to examine one particular witness to substantiate, there is no need to examine 10 people there. So the court may refuse summons under Order 16. So it is an interlocutory order, cannot be challenged. Order then order refusing the condonation of delay in filing document. Now, when you file a plaint, as a plaintiff, you are bound to disclose all the document and exhibit the document. That is the requirement of Order 7 of the CPC. Order 7, Rule 14 mandates that. Similarly, Order 8, Rule 1A CPC mandate defendant to disclose all document. And if you don't disclose it, you will not be permitted to use those documents in evidence. Now the court has given you time. Under Order 7, Rule 14, you are not exhibited the document, not furnished the copies. Please file it within a period of 7 days or 10 days. वो नहीं किया आपने. So order rejecting is an interlocutory order again. समझे ना आप? Now similarly under injunction under order 39 rule 1 and 2 the court passes an order of injunction. 39 rule 3 says notice should be given to the other side before passing an order of injunction. The proviso to 39.3 says notice can be dispensed with in cases of emergency. If the notice is given, it may defeat the purpose of the suit. See, the court may pass, that is called an ex parte order of injunction. Ex parte means without notice. And the plaintiff defendant has not filed a caveat under 148 ACPC. So you may take the advantage. If I give the notice, it amounts to, he will abuse he will dispose of the property. If I give notice to him, the horse will be fled. So there is urgency in the matter. My property I am being dispossessed from the premises by my landlord, by my neighbor, without following the due procedure established by law. And he cannot take the law in his own hand. And there are quarrels. He's gone to the police station, lodge a FIR against me, and a complaint. And the district magistrate file a complaint under 145 CRPC. Proceedings are started. Property attached under 146. So you go to the civil court because the order of the magistrate is not binding upon a civil court. A civil court is the one which determines the right title interest. I am in possession, occupation, enjoyment. See this is my document. The defendant is a trespasser. He has no right. He is trying to influence the authorities. This honorable court be pleased to pass an order of injunction immediately restraining him not to enter into premises. Court may pass it. Court will give a direction that furnish the copies in advance. Later on, after the injunction. Agar aap copy nahi pay kiye, the order will be vacated. Okay. So, you make application for condonation of delay. That may be rejected. It's an interlocutory order. Okay. Then under the provisions of order 37, summary suits you file. Isn't it? Under 37, defendant does not have a right to file written statement without the leave of the court. All of you know that. Isn't it? That leave is rejected. Though it's an interlocutory order affecting your rights. You have a right to file an appeal against this order. Under Order 1, Rule 8 CPC, you file a suit in a representative capacity. Seek a leave, my lord. I am affected and the suit is being filed for myself and on behalf of thousands of people who have been issued notice for demolition by the corporation or Mahada. Leave may be granted to file in a representative capacity. It's an interlocutory order again. Either you have a right to appeal against the order or you may accept it. Let everybody file a suit. There is no mandatory requirement that everybody should file it. One suit can be sufficient.
Sir, could you re-explain the order 37 that leave is
Order
mandatory?
37, Rule 1 and 2 CPC, summary suits. Isn't it? Civil suits are two types for recovery of money. One is a summary suit, one is a regular suit. Summary suit would lie only in respect of admitted claim. Number one, check bouncing cases. Number two, hundi, promissory note, or liquidated damages where the claim is not disputed. Contract which is admissible contract. Document. But whereas if there is a disputed facts, contentious issues, fraud is played, time barred case, then summary suit will not lie. You have to file a regular suit. Kya bolte hain? Regular suit. In a regular suit, when you file a plaint, defendant automatically gets a right to file written statement under Order 8, Rule 1 CPC within 30 days, 60 days, 90 days, depending upon what is the period of time. But whereas in a summary suit, the defendant does not get, as a matter of right to chance, file a written statement. What he should do? File appearance within 10 days. Plaintiff will file a suit. Plaintiff will take out summons for judgment. क्या बोलते हैं?
Summons for judgment.
Summons for judgment. वो summarily decide होता है. At that time, when you receive the summons for judgment, within 10 days, you must file appearance to yourself or the advocate and tell the court the summons for judgment and the summary suit is false, frivolous, it is time barred. There are contentious issues. The amount is not the amount. The plaintiff has played a fraud upon me. The transaction has not taken place. There are tribal issues in the present matter. क्या लिखेंगे आप? There are tribal issues. Hence, this honorable court be pleased to grant leave in permission to the defendant to file written statement and the summons for judgment be rejected. See, the court will consider the documents of the plaintiff. यहाँ पे no question of leading evidence. Court will see the documents correct है नहीं है. Number one, whether the plaintiff has come within 3 years time in a suit for recovery of money 3 years time when you go under the Limitation Act. 3 years के बाहर रहेगा तो you will automatically get leave. And if you take up the plea that year, the check has been fabricated and no transaction taken place, there is no enforceable liability. Check will be dismissed. But if you have borrowed money and you have issued check and no explanation coming forward, the court will say prima facie, yes, there is a clinching evidence that it is your check and you are not, notice has been given to you, you are not replied. Why should you be given leave? Court क्या बोलेगा? I will grant you leave, conditional leave. Deposit the money. 1 crore का claim है, you deposit at least 50 lakhs. Let the money be invested, whoever wins will get it. That is called conditional leave. That conditional leave or refusal of leave again is an interlocutory order under Order 37. So these are not final order because they don't dispose of the suits. Please note that here. Though you may have an appeal under the provisions of the law, either the latest patent appeal or section Order 43(1), but it is not a final degree. Okay, that is one thing. Then I already gave you the example just deciding the question of admissibility of document under the provisions of section 136 of the Evidence Act. It is again then order granting or rejecting amendment under Order 6, again interlocutory order. So you may choose to bring a new cause of action which may be different. Huge power is given to the trial court. Huge power is given to the trial court to allow the application or refuse the application. The defendant died, you want to bring the heirs on record. Some gentlemen say, I am the purchaser of the property. He will take out application under the provisions of Order 22, Rule 10 CPC. I am the assignee. Application may be allowed, may be rejected. It's an interlocutory order. Normally, the application should be granted. You heard the expression and transfer of property pendentilite, list pendants. पढ़े ना आपने? Section 52 of the Transfer of Property Act, list pendants. List pendants notice. A suit is filed by you against me. I am the defendant. During the pendency of the suit, without notice to you, I transfer the property to Mr. C. Isn't it? That C can be brought on record. Exercising the powers under the provisions of Order 22, Rule 10 CPC and also Order 1, Rule 10. You must say he is a necessary and proper party. That is also covered under the Transfer of Property Act, section 41 and 42. Doctrine of feeding the estoppel. कभी सुने आपने? नहीं, पढ़ो. Section 42, 43 of the transfer of property. If you want to be a full-fledged lawyer, you should be knowing almost every provisions of the first year, second year, third year. Don't forget. Doctrine of feeding the estoppel. पढ़ो, बड़ा interesting है topic. I mean, what is an ostensible owner? What is a real owner? What is a benami owner? What is the doctrine of estoppel? I may have no right at the time of the filing of the suit. Subsequently, I acquire a right from my grandfather's will. So tomorrow I cannot deny I am not the owner. So estoppel will come into play. Isn't it? So it is called doctrine of feeding the estoppel, which is covered under section 41, 42 of the Transfer of Property Act and 115, 116 of the Evidence Act. I think my junior indicates that your time is up. We can stop. You can ask me question. I will take some of the question. The topic is lengthy, but we can keep one more topic. Of course, the CPC is a very vast. When we take lectures, we'll again.
There's only 10 minutes, so we can entertain questions.
Yeah, I will entertain question. Please ask question, preferably directly.
There are no chairs.
Hopefully, this topic is clear to you all.
Yes, sir.
Yes. Right. So today being a working day, many of the youngsters working, they will listen to the lecture later on. All right. As far as possible, I try to take lectures on Sunday because everybody can attend. I had to convince my junior.
Linking section of specific relief act.
Linking section?
Linking section of specific relief act.
Yes. Under the Specific Relief Act, section 37 deals with temporary injunction. That is equivalent to Order 39, Rule 1, 2, 3 of the Code of Civil Procedure. But permanent injunctions are covered under the Specific Relief Act.
Section 10 of specific relief locates
Section
to
10 of that is for specific suits for specific performance.
Okay.
That is suit for specific performance of a contract, section 10. Okay. A contract is broken. Then suit for a perpetual order of injunction.
Oh, yes, with respect to the builder. If the builder is not giving the property, then contract is wrong.
Giving a file a suit first, then injunction lenge aap. Injunction will be covered under the provisions of section perpetual injunction, section 38, mandatory injunction 39, and temporary injunction 37, specific relief act, read with order 39, rule 1 and 2 CPC. Okay. Section 10 में suit. Without a suit, there cannot be injunction. There cannot be notice of motion or interim application. और कुछ पूछना है? Only 3 लोग हैं.
You could just briefly repeat that section 52 less pendants notice and for principle of estoppel.
See, list pendency is A has filed a suit against B. During the pendency of a suit, C sells the property to B sells the property to C. So despite having knowledge of the suit, he sells the property. But if A, the plaintiff, records his list pendants before the registry, the sale is normally void. The registration office will not register it. Assuming you have not filed the list pendants, still the buyer has to be very aware. He has to take various steps, including finding out from the court of law when any suit is pending. So any person purchasing the property, unless he is a bona fide purchaser without bona fide procedure for consideration and without notice, he may be protected. But if he is a next door neighbor, he knows the fact that a suit is filed, he will not be protected. Suit
So
is
similar to caveat. A little similar to caveat.
yes. You are having notice of the litigation. Despite litigation, you are purchasing it. So you are bound by the decree. You are bound by the decree. Estoppel comes into play. Suppose there is a Benami transaction where a husband files a suit, takes property in the name of the wife. Then relation between husband and wife are strained. Wife will file a suit for declaration that I am the real owner. And she tries to evict a tenant who is in possession.
Sir, we'll read up on it, sir. We'll
Yeah.
read up on 41, 42, 43 and 115, 116.
Yeah, sir. Okay. लंबा टॉपिक है, बंद करें. Okay, चलो, all the best. Good night.